The next one is power of attorney for personal care. And personal care is not just medical treatment. It can cover where you live, accommodation. It covers diet, covers clothing, safety, and hygiene. And you can have different attorneys for different parts of that. Here we go again with the screen. Oh, I did. It's fine. Just remember that personal care covers all aspects of that. In this case, you can be 16 and give power of attorney for personal care, but you have to be mentally capable. And this definition of capacity is a little different. You have to have the ability to know whether the proposed attorney cares about you and is concerned for your well-being. So you have to be pretty cognizant of that person's intentions when they're going to help you, and that they need to make decisions for you if you're not capable, and that you basically can trust them the way you would trust someone with property to do what would be in your best interest and what you want in terms of your well-being. And just like property, you don't have to be capable of managing your own personal care to be able to grant a power of attorney for personal care. Because the law wants you to be flexible enough to get that help when you need it, as long as you're mentally capable enough to understand those things. So choosing the attorney, this is a bit different. It may not be the same person you choose for your power of attorney for property. Some people aren't good at hospitals. Some people aren't good dealing with medical crises. They get overwhelmed, and so you may end up picking a different person for your power of attorney for personal care. And the other key thing is you want the person to understand you know how you like to live, your wishes, your values, your beliefs, because it's personal, obviously. And you also want the person to be able to communicate with the other family members and friends. It's not something that should be isolated. You should keep the person surrounded by people who love them if they have those people. Don't shut people out. This is unfortunately something people try to do when they get the power, but this is not what the law intends. And there is a restriction because they don't want people who are in it for money. Unless you're a relative or a spouse or a partner, you can't be somebody who provides health care or residential care. Like you can't be a landlord or social work or something like that for this person unless you are related to them in this way. And once again, just like in the power of attorney for property, multiple attorneys could be appointed to act either together or individually. But once again, you have to remember, are they going to be around together if you're going to say that they're going to be deciding together? Okay, so who assesses the capacity for personal care? Because a power of attorney for personal care will only come into effect if you're not capable of making the decision yourself. So it's generally a healthcare practitioner because you might be in the hospital. But in your power of attorney for personal care, you can specify how your capacity shall be assessed, just like in the other power of attorney. So you could say you want a physician to do it or a designated capacity assessor to do it. Just because you want to hold on to the independence to make those decisions as long as you can. And a doctor will always ask you first, this kind of gets into the area of consent. Let me talk a bit about that in a minute. As I mentioned, it's only effective when you're not capable. And here's a definition on the screen of capacity in this context. You have to understand the information that's relevant to your decision. So let's say it's a diagnosis. You have to be able to understand what the doctor's telling you about what could happen if you don't get treatment or if you do get treatment. And you have to sort of appreciate what the consequences of making a decision or not making one. And just try to, it has to be an appreciation of the risks and the consequences. So if you have that, then you're capable of making a power of attorney you're capable of making your own decisions. Otherwise, you may need someone to make them for you. Now, the duties of the decision maker, one of the things that is a feature of that particular power of attorney is there's a space to write your wishes down for future care. So if you have a strong belief that you do not want a certain kind of treatment, like you never want a feeding tube, or you never want chemotherapy, or there's something that you feel really strongly about, you can place it in that document. But it's only going to be a wish. It's not a hard and fast rule for your doctor. You have to realize that the doctor is going to presume that you're capable unless he or she has reasonable grounds to think you're not, and is going to approach you every time, because capacity can change over time. It can come and go. So they have to approach you every time to ask if you're going to consent to this treatment. So if you're the attorney for someone who doesn't have capacity, you have to consider, is this going to improve the person's quality of life, or is it going to make it worse? And you have to base your decisions as much as you can on what that person has told you, either in writing in their power of attorney or just in a conversation. And that's why it's good to keep talking with your loved one to make sure that you're on the same page as to what they want, because they may have changed. And it's a very difficult decision. I had a decision to make with my brother when my dad was 95, and there was a question of putting a pacemaker in. And one of us felt a little bit differently than the other, but we have to go with what my dad wanted, even though it might not have been what we wanted, if we were in that position. But we had to be governed by what he wanted and what he had expressed. Okay, so once again with these documents, you can put in restrictions and conditions in. I did mention that you can, your wishes are general guidelines. You can also specify that it has to be an assessment in writing from a medical professional or a designated assessor before you can go ahead. You can also put things in like that you want to donate your organs and so on, although it's good to have there is a registry for that in Ontario if that's something that you want. And that's something also that you can put in your will. Execution, it's again in front of two witnesses, and they can't be they can't be the attorney or a close relation to the attorney, and they have to be at least 18. The witnesses always have to be at least 18 years old, even though for a power of attorney for personal care you can be 16 to give it. When does it end? It ends on the death of the incapable person, or when they revoke it, make a new one, or when the attorney dies or resigns or becomes incapable. And also when the court appoints a guardian of the person. So that might be in a situation where someone has challenged the attorney who is already in the power of attorney and have gone to court to replace them. If the court appoints someone else, then that power of attorney would end and a guardianship would take over. All right, so what if you don't have a power of attorney for personal care? Well, unlike property, there is a hierarchy in the Healthcare Consent Act that will allow a medical professional to approach someone in your family to make the decision if you don't have that in place. And the hierarchy, they will first go, if there is a guardianship in place, they'll go to that person. They could go to the attorney for personal care, or they could go to a representative appointed by the Consent and Capacity Board, which is a body that determines whether or not a person is capable or incapable, and you can apply to be a representative for the person. That doesn't involve property, but you might be the representative for the person of that, of your loved one. So then they'll go to the spouse or partner, the child, brother and sister, and if they have a bunch of brothers and sisters, everybody's on the same level. They all have the same decision-making power, and then any other relative. And as a last resort, the public guardian, but that's quite rare because the public guardian wants the family to do it if they can. A couple of years ago, I believe that it was estimated that there were 17,000 people who are under a guardianship order in Ontario. that's probably gone up since then, but that's part of the reason why the public guardian and trustee wants the family to do it, if possible. So that leads into this area.